The Koompahtoo Local Aboriginal Land Development Council owned an area of land north of Sydney. In 1997, they entered into a development agreement with a corporation called Sanpine Proprietary Limited. Under the development agreement, Koompahtoo would provide a relatively small portion of their overall lands, which Sanpine would develop into residential blocks, with the proceeds to be split 50-50 after management costs were taken out. Sanpine's management seems to have been disgraceful. Not only were they unable to obtain approval for the subdivision, but they obtained multi-million-dollar mortgages against the land in the subdivision, placed that money in their own account, not a joint venture account, and failed to report how that money was spent. There were no audited accounts. In fact, there were only the most rudimentary accounts of any type. Eventually, Koompahtoo terminated the contract on the basis that Sanpine had repudiated the contract. That is, Sanpine had breached the contract in a way which justified the termination of the contract. Sanpine opposed this on a number of grounds, but the one that made it to the High Court was whether the clauses breached by Sanpine were sufficiently important to allow Koompahtoo to terminate. Traditionally, contractual terms have been divided into three types: conditions, which are important enough that a breach justifies termination; warranties, which are less important terms where breach only justifies an award of damages; and intermediate terms, which can sometimes be breached in ways serious enough to justify termination, and sometimes in ways less serious. The majority judges in this case relied on the doctrine of intermediate terms, arguing that the doctrine gives the court greater flexibility by allowing the court to look not just to the terms of the contract, but also to the consequences of a breach. They said the focus of attention should be the contract and the nature and seriousness of the breaches. The intention that is relevant is the common intention of the parties at the time of the contract as to the importance of the relevant terms and as to the consequences of failure to comply with those terms. This case confirms that the doctrine of intermediate terms is part of the law of contract in Australia, and it also encourages courts to consider, for any breach, whether the consequences of that breach might be sufficiently serious to allow a party to terminate the contract.